monthly employment law update, the first of the year for 2021. We've got quite a lot to cover, and surprisingly actually not everything is related to furlough or coronavirus situation, but the first point that I am going to cover is in fact related to coronavirus and relates to the coronavirus job retention scheme guidance and the fact that it has been updated. Now, the update that the government has made to the guidance is to ensure that everybody is very clear about the fact that individuals that have caring responsibilities, so whether that be parents who have children at home, or alternatively they are the carer for a vulnerable adult or individual within their household, that they can access the furlough scheme. So the guidance was updated just 3 days ago on the 5th of January in order to be able to ensure that both employers and employees are very clear about the provision for the furlough scheme and that it does cover these individuals, particularly obviously in light of the fact that as a result of the latest lockdown and the closure of all of the schools, that is obviously putting a huge amount of strain on working parents. Now, in terms of the actual furlough scheme itself, that while that gives individuals access, I say individuals access, whilst it provides the opportunity for individuals to access it as long as there is an agreement between them and their employer. So there is no specific obligation on employers to actually furlough individuals who have children at home as a result of the school closures. So this is going to be an interesting dynamic and an interesting thing for employers and employees to have to deal with, because of course if you can work from home, then the guidance is that you should work from home, but many people are going to find it difficult to work from home, particularly if they've got young school-aged children who need homeschooling, and they need greater care and attention than perhaps an older teenager would do. And there are possibilities of indirect sex discrimination issues arising out of employers who perhaps aren't furloughing employees who are in that situation, particularly obviously female employees who are in that situation, perhaps single parents who are in that situation. So it's something that we will all need to deal with on a case-by-case basis, but it's really just to confirm that actually as far as the government is concerned, as far as the scheme is concerned, then access to the scheme is available. And in fact, in a relatively interesting development, the Swiss insurance firm Zurich, they have introduced what they've called lockdown leave, which is constituting 2 weeks of paid leave for parents who are facing emergency childcare issues. And so whether we see this as a part of a pattern, I would imagine that there is of course clearly huge financial issues that many employers are having to deal with, and quite frankly providing a scheme such as is being provided by Zurich may be beyond many at this time. So I completely appreciate that, but just making you aware of perhaps of what the specific trends are at the moment and what some other companies are doing. So that's the latest update to the CJRS guidance, the furlough leave guidance. Now, the next issue that I just want to talk about is in relation to restrictive covenants. Now, I completely accept that restrictive covenants isn't the most interesting topic in the world. They really don't set the world alight, and it's actually very rare. I say very rare. It's not often that companies and individuals will get into conflict about the restrictive covenants, despite the fact that, of course, they appear very regularly and very commonly in employment contracts. But they then tend to get forgotten until that employee then goes off to work for a competitor, and then there's a frantic search and analysis of the employment contract to see whether there is the clause there and to what extent it may be able to prevent them to going and working for the competition. Now, what's happened is that the Department for Business, Energy and Industrial Strategy of the government is consulting on measures to reform these non-compete restrictive covenants that are commonly used by businesses. And it's mainly considering two things. So it's looking at changing the law so that non-compete clauses are only enforceable if the employer provides specific compensation during the term of the clause. So, for example, if the restriction is to last for 6 months, so for 6 months after leaving your employment with a particular company, that you cannot then go and work for a competitor, then the proposal is that then the ex-employer will then have to pay a percentage of the salary during that restrictive period in order to ensure that that it's then a lawful restriction. And what we're looking at, or I say what we're looking at, what the government is looking at is a restriction, a provision of payment of anything between 40 to 100% of salary during that period. The other option that they're considering is barring non-compete restrictive clauses from employment contracts altogether. Now, what they're talking about at the moment is simply non-compete clauses. So it looks like the other the other restrictive clauses that are frequently used within contracts, so such as non-dealing clauses, non-solicitation clauses, because they're often seen as less onerous, and so they're more difficult to enforce, then we can't really see that they're going to be banned altogether. But particularly large organisations, say those within pharmaceutical sectors, or where there is particular intellectual property that is very, very important, then this could be, of course, a very important issue. So this consultation is going to be very relevant in some sectors. And of course, we've got confidentiality clauses that we can also use within contracts, but it's often difficult to actually get evidence of any breaches of confidentiality clauses, and so that's why these non-compete clauses are often used, just to ensure that there is that protection of the legitimate business interest of the employer. So the consultation remains open. It's open until the 26th of February of this year, and there is no timescale yet as to when the government might respond. So there's not going to be any immediate movement on this, but certainly something that if you're a regular user of restrictive covenants, it's something that we're going to have to keep an eye on. Now, this is just a brief notification really to let you know that the statutory sick pay regulations have been updated. Again, this is in fact the statutory sick pay open brackets general close brackets open brackets coronavirus amendment close brackets open brackets number 7 close brackets regulations 2020. So essentially, as you can see from that, this is now the 7th update to the statutory sick pay regulations that was specifically introduced to deal with the situation in relation to the coronavirus pandemic. Now, the amendments that have been made to these regulations simply reflect the changes to the self-isolation requirements where individuals with symptoms of coronavirus, or where they test positive for coronavirus, or are in a household where they would have contact with an individual who has coronavirus, it's to ensure that they can self-isolate and receive statutory sick pay during this period of time. Now, as a quick reminder, you cannot use the furlough scheme, and certainly under the current guidance that is issued, you cannot use the furlough scheme for short-term periods of absence. So therefore, we are only looking at using this sick pay regime, the statutory sick pay regime, in order to provide payment to individual employees. Now, of course, there is then often a question about whether the company's contractual sick pay is potentially triggered by somebody who is self-isolating in these circumstances. Now, that's going to be something that we would have to determine on a case-by-case basis by having a look at your specific clauses that you have in relation to your contractual sick pay scheme. But there may be some instances where you are not required to pay your contractual sick pay, whether that be full pay or 50% of pay or whatever that might be, over and above the statutory sick pay in circumstances where somebody isn't actually sick. Because of course, if somebody is required to self-isolate because they have symptoms, it doesn't necessarily follow that they are actually unwell. It just simply means they have got symptoms of COVID. So if you lose your taste and smell, you're not necessarily unfit for work under the terms of your normal contractual sick pay scheme. You might be in relation to obviously all of the rules that are in place in relation to the law requiring you to self-isolate, and then the triggering of the statutory sick pay regulations, but not necessarily in relation to contractual sick pay. So that's something again for you to bear in mind if you are worried of abuse of the contractual sick pay scheme in such instances. So moving on to Brexit. So yes, we've covered a bit of coronavirus issues, and now we're moving on to Brexit, because of course Brexit did finally take place at midnight on the 31st of December 2020. Now, the Information Commissioner's Office has now published guidance on essentially to ensure that data continues to flow between Europe and the UK, and so it's helpful guidance to try to ensure that the data continues to flow, but also to ensure that the information controllers, so businesses, are still continuing to comply with the Data Protection Act 2018 and of course the General Data Protection Regulation. And what they're saying is that we should continue to use the standard contractual clauses that no doubt you've been using before for when you're transferring data from country to country. You should review your privacy information and amend anything that's necessary in order to reflect the end of the transition period that of course we've now reached. Now, just to give you a little bit of an update as to where we are in relation to data protection following Brexit, there hasn't been any decision made by the EU yet as to whether it's going to accept the UK's data protection regime as adequate. The ICO has stated that an adequacy decision is still possible, but the timing is unclear. So it's really a case of watch this space. But in relation to your day-to-day operations, then you should ensure that you're using your standard contractual clauses and continuing to comply with the requirements of the Data Protection Act 2018 and the General Data Protection Regulation. So essentially carry on as you are at the moment. But there is some new guidance that's available from the Information Commission Officer's website. So flying through the content at the moment, we've got quite a lot to get through, and as you can see again, there's another Brexit update here. So this is all in relation to national insurance and social security. So the HMRC has published new guidance on national insurance and social security contributions for the UK and EU workers in order to help everyone following the end of the transition period. Now, the guidance provides an overview of when workers from the UK who are then working in the EEA, the European Economic Area, or in Switzerland will have to pay UK national insurance contributions, and when they will need to pay social security contributions in the country in which they are working. It also deals with issues in relation to EEA and EU nationals or Swiss workers coming to the UK, and when they need to pay social security contributions in the EU, and when they need to pay social security contributions in the UK. Okay, so again, this is, I'd imagine it's simply because the Brexit deal was done so late in the day that, again, we're being told in the same way that we're being told in relation to the Information Commissioner's guidance, and essentially is watch this space. So in relation to data protection, there's some guidance and watch this space. In relation to the treatment of national insurance and social security, there is some guidance from the HMRC, but watch this space because there will be more to come. We then turn to some, again, not Brexit related or in fact furlough related. So this is guidance, again, published by the ICO, and this is about the use of algorithms, so AI systems in recruitment processes. So they have outlined in some guidance 6 points of consideration for organisations who are seeking to implement algorithms in their recruitment and hiring process. And so what they're doing is they're highlighting the fact that these artificial intelligence systems that are used in recruitment processes can often be influenced by human bias. And so it's ensuring that where businesses are using AI, that they shouldn't do it to solely make automated decisions for hiring people. Whilst it can be part of the process, it shouldn't actually drive the overall decision itself. But they've also stated again, and this is set out in the guidance, that the algorithms can help avoid, say for example, unconscious bias or other more human aspects of unequal treatment that can otherwise lack control when it's a more human-based decision-making process. But so this is obviously something which we're seeing AI in a lot of areas, and in particular in the recruitment business. And I'm sure that we will see the growth in it. But as we see the growth in it, there are likely to be future challenges in relation to the design of those systems and whether in fact they are being inherently discriminatory or not. So again, if you're a business that uses such systems within recruitment, then I certainly encourage you to go along and have a look at the ICO guidance that's been published on that. Now, gender pay reporting. So the Government Inequalities Office has published some new documents to try to help employers in meeting their gender pay reporting requirements. So this guidance is explaining the sort of data that you've got to collect and how the calculation is made, how the calculations are made, and how you add that supporting narrative. Now, of course, businesses have been having to provide gender pay information now for a few years, and so this is nothing new, but there's some helpful additional guidance there. In addition to that, we've also seen from the Office of National Statistics the publication of gender pay gap statistics for 2020. So what the Office for National Statistics are saying is that, in terms of the main points that has come out of the data, is that for full-time employees, the gender pay gap has fallen in the past year from 9% to 7.4%. And for all employees, the decrease in that same period has been from 17.4% to 15.5%. Now, of course, the reason for that that incredibly stark difference between those two figures is, of course, because the predominant grouping of part-time workers is made up of women. The predominant proportion of part-time workers is made up by women, and so we then see this this structural element within the labour market then being reflected within the pay gap, which is still obviously very significant indeed. For full-time employees, and this is where we see another interesting part of the data, is that for full-time employees under the age of 40, the pay gap was close to zero. But for older employees within this, but for older age groups, the gap increases to over 10%. And in fact, there's an organisation called Rest Less, which is a digital community for the over 50s, and they've published an analysis of this Office for National Statistics data, which has revealed that women over 50 years old earn on average £8,427 less than their male counterparts per year, which amounts to a 23% pay gap between full-time workers, and a figure that then rises even further to 25% for the over 60s, but then falls down to only, I say only, because of course there shouldn't be a pay gap, but it falls to only 3% for 18 to 21-year-olds. So what they are saying in their analysis is that women over the age of 50 face a double discrimination, both in terms of age and also wage disparity. So clearly, gender pay is an equal pay, although they are different. But I won't go into the legal differences in respect to that quite now. But of course, the fact that you have a gender pay gap, it doesn't, as within your business, it doesn't necessarily follow that you have an equal pay problem, because of course what you need to do in terms of equal pay is you need to compare comparable work. But equal pay is increasingly an issue. The Equal Pay Act has been in place since 1970, and as you can see here we are 50 years later, over 50 years later now, and we've still got significant pay gaps between men and women. And so we're seeing an increase in the number of equal pay claims that are being brought, and so we need to ensure that you have robust systems in place in order to provide for equal pay within your business. And so pay structures, pay grading, and robust systems by which pay is determined is important within your business. And if you don't have that, then you are leaving yourself somewhat exposed to potential challenges on an equal pay basis. EU Whistleblowing Protection Directive. Now, I'm sure you're probably sat there going, but hang on a second, we have left the European Union, and so therefore this doesn't affect us. Well, yes and no. I mean, yes, you're quite right in that we have left the European Union now, and as a result of that, the effect of this directive is negligible. But it could well have an effect, not in terms of its specific application within the UK, but the fact that the European Union are setting out some standards which the UK government therefore may choose to follow in their own domestic legislation. So are the UK actually going to turn around and implement the provisions that are set out within this EU directive in relation to whistleblowing within the UK directive? That's simply not clear. But what we have seen is, albeit that it's now just over a year ago, because we're going back to August 2019, but we did see the UK undertake a review of whistleblowing law within the UK, at which point it said that it concluded that it was complicated, overly legalistic, obsolete and fragmented. And so there is pressure within the system for the UK to review its whistleblowing protection legislation. And so there could be moves within the future, or there could be pressure in the system being built up as a result of the EU directive. Now, just very briefly in terms of the EU directive and what it provides for, it ensures that all forms of retaliation against whistleblowers by their employers are prohibited. Now, of course, we've got something similar set out within UK legislation, because it is unlawful to subject any employee or worker to a detriment as a result of blowing the whistle. The EU directive obliges legal entities with over 50 workers to implement specific internal reporting channels to ensure that whistleblowers' identity is kept confidential, and also to designate the authorities competent to receive and to give feedback and to receive and to provide follow-up reports on whistleblowing complaints. And it also provides for effective and proportionate and what it calls dissuasive penalties for persons that hinder reporting or retaliate against whistleblowers. So it does go a bit further than the UK legislation does at the moment. So it will be interesting to see quite how the UK government reacts to that. As a general rule, in terms of how you should be set up at the moment, how your business should be set up at the moment, in order to deal with whistleblowing legislation, is to ensure that you have a whistleblowing policy, and ensure within that policy that you set out the procedures by which your employees can confidentially report concerns about illegal or unethical or unacceptable conduct. you've got to publicise the policy. You've got to make sure that people know about the policy and train management in that policy and the principles of its operation. You've got to investigate disclosures promptly, keep the whistleblower informed as to the progress where that is possible to do so. Don't rely on confidentiality clauses to prevent external disclosures, and in any event, section 43J open brackets 1 close brackets of the Employment Rights Act now renders any contractual terms that actually prevent that as void, insofar as they prevent somebody from making a protected disclosure under the Act. And consider introducing a confidential whistleblowing helpline. So that deals with our EU whistleblowing directive. Now, getting on to a little bit of case law now. So the first case that we're just going to have a look at is the Heskett and Secretary of State for Justice. Now, this case deals with the concept of the cost plus justification in relation to indirect discrimination cases. And the basic theory here, the basic idea here is that cost in itself cannot be used as a justification. So it was too expensive to rectify the disadvantage, should not be relied upon by employers, or should not be used as the justification to then defend claims. And this is particularly important because what it does is this: where an employer argues that its actions, albeit indirectly discriminatory, were in effect forced on it by external factors with which it was having to cope. Now that's what we're dealing with in Heskett. So just to give you some facts of the case. So in Heskett, it was in relation to the probation service. And what the probation service did was it altered the promotion scales, which disadvantaged younger employees. But the reason that it did it was in response to economies required by government policy. Now, the Employment Tribunal and the Employment Appeal Tribunal accepted that this was justified, and they commented that it was necessary to, quote, square the circle brought about by government policy. Now, the upshot of all this is that there is certainly an established principle that saving or the avoidance of costs will not, without more, amount to the achievement of a legitimate aim. So just if I just go back a little bit, because I'm probably not explaining that absolutely perfectly. So we've got an original case of Woodcock. Now, in the case of Woodcock, it didn't actually state that cost alone is not sufficient to justify discrimination. But what it did say was that, to quote, the saving or avoidance of costs will not without more amount to the achievement of a legitimate aim. Now this has resulted in everyone referring to it as the cost plus rule, or the cost alone, or the plus factor, which what's happened is that in this Heskett case is that they've said, well, that's quite actually a potentially lazy or slightly misleading way to approach it. So what they've done is that in the Heskett case, there's a subtle change in emphasis that they've provided. So under the cost plus approach, the emphasis was on whether the actions could be legitimized by showing more than just cost. Whereas the approach in this case, in the Heskett case, puts the emphasis on whether they can be shown to be illegitimate. So whether the measures are illegitimate because they are put in place solely to avoid the increased costs. So effectively it's switching it round the other way. It's placing the burden more on the claimant to show that the justification used by the employer in relation to cost is illegitimate, rather than placing the burden on the employer to show that it isn't just cost, it is cost plus. Okay, so it's the reason that this case is particularly interesting is that it's likely to make it's a beneficial decision for employers, in that it is providing greater scope for argument in relation to cost in discrimination cases. Now, it's still the case that cost alone is unlikely to be something that is going to justify discrimination, but of course it is all going to rely or turn on the context and the facts of the case, and what is it that is driving the cost factor within the decision-making process. Okay, so an interesting case in relation to the cost plus concept within discrimination and within indirect discrimination. Now, the next case to turn to is Kemsen Scotland Limited versus Ure, and this is a constructive dismissal case. Now, just as a little bit of a reminder in terms of constructive dismissal. So, as I'm sure you're probably aware, so the statutory definition of constructive dismissal is set out in the Employment Rights Act, which states that the employee terminates, or should I say, it is constructive dismissal in circumstances where the employee terminates the contract under which they are employed, with or without notice, in circumstances in which they are entitled to terminate it without notice by reason of the employer's conduct. So it's important to note that the employee may resign with or without notice. What matters is that they should be entitled to terminate the contract without notice. So what I'm saying there is a lot of people get caught up on but they've given notice to terminate rather than just immediately resigning. And that isn't something that is particularly relevant, although of course in most circumstances employees do tend to resign with immediate effect. Now, the lead case, Western Excavating and Sharp, that set out a number of elements that needed to be established in relation to constructive dismissal. And so this is that the employer has got to breach the employment contract, and it's got to be a sufficiently serious breach in order to justify the employee resigning. And then the employee has then either got to accept that breach and treat the contract as being terminated as a result of the breach, and they must resign in response to the breach. And they mustn't wait too long in accepting the breach, as if they do wait too long, then it's open to the employer to then argue that that breach has been waived, and so therefore the contract is now is continuing, and so therefore it's now too late to resign. So those are the principles within which we're working in relation to constructive dismissal. Now, at one stage it was also considered necessary that where a departing employee is leaving in such circumstances, that they have to make it clear when they leave as to what the reason for leaving is, if they then wanted to later rely upon that ground as part of a constructive dismissal claim. Now, going back to 1999, the Court of Appeal rejected that in a case of Wethersfield versus Sargent, in which they said that it wasn't necessary for the departing employee to set out in writing as part of their resignation what the reasons for the constructive dismissal was. Now, that's been essentially reaffirmed, or in this case with Kemsen Scotland, or at least it's a good example of the Wethersfield principle. Now, the facts of this case, they're a little bit awkward because it involves a family firm. So we've got the claimant who was on maternity leave, and during her period of maternity leave things became slightly difficult for her within the firm, and she objected to a number of acts of the management, and the management being in fact her father, during her maternity leave, and those acts by the management were held by the Employment Tribunal to be repudiatory. But she didn't resign at that point. In fact, what she did was simply not return when her maternity leave ended. And then when her maternity leave ended, she then simply brought proceedings for constructive dismissal, constructive unfair dismissal in the Employment Tribunal. And the employer appealed against the decision of the Employment Tribunal to uphold her claim, and they appealed to the EAT partly on the basis that simply failing to return without any explanation could not and should not be enough to show that there was a repudiatory breach that caused her to leave, and essentially saying that too much time had passed, and in any event she hadn't actually put in writing what the reason for her resignation was, or should I say what the reason for her simply not returning to work after her period of maternity leave was. But the Employment Appeal Tribunal dismissed this appeal, and they held that it was a question of fact in the circumstances as to whether somebody's non-return to work and being silent upon that non-return to work was an acceptance of the repudiatory conduct, so essentially the resignation triggered by the breach by the employer. So it's something that we need to be alert to, and when I say alert to, we can't simply assume that because somebody isn't setting out in detail within their letter of resignation, if in fact we get one, what the reason for them leaving is, that in fact they're not going to be able to bring a constructive dismissal claim. Of course, it's helpful for any claimant who is resigning. It is common for them to set out within that letter why they are resigning, and in fact I would say it's probably advantageous for them to set out in that letter why they are resigning, but the fact that they simply don't isn't fatal in any way in relation to any future claim for constructive dismissal. Interim relief and discrimination cases. So this is going to be a very interesting one to watch in 2021, because just again to bring you up to speed, or a bit of a revision in relation to interim relief. So interim relief is something that is normally or is specifically restricted to whistleblowing claims, trade union related claims, and some other automatic unfair dismissal related claims, such as health and safety representative issues, pension trustee issues, and the like. What interim relief does is it enables a dismissed employee to bring a claim within 7 days of their effective date of termination in an employment tribunal, in order to effectively force the tribunal to continue to employ them and therefore continue to pay their salary until the substantive claim is heard by the employment tribunal. Because of course normally what would happen if you're dismissed, then you bring the claim in the employment tribunal, and during the intervening time you are therefore without work and without pay, unless of course you find yourself alternative employment with a different business. What interim relief does in some circumstances is it actually puts you back with that employer and with your salary until the claim is heard, which of course, given the current backlog of employment tribunal claims within the system as a result of the COVID pandemic, that could be a year, 2 years, perhaps in some instances even longer. So it's a very powerful tool, albeit that it's a tool that is very rarely used. And in terms of the bar that has to be cleared by individuals when they are bringing such claims, they have to show that their claim has a real prospect of success, or to quote a couple of cases. So the bar, like I said, the bar that is set is that they've got to show to the tribunal, the claimant has to show to the tribunal that they have a, quote, pretty good chance of success. That was in the case of Taplin and Shipham, or alternatively that wonderful, and I think this is a wonderful phrase in relation to, you know, a legal test, that the case, quote, looks like a winner, and that was in the case of Derby Daily Telegraph and Foss. But this interim relief has not been available for discrimination claims. So like I said, it's been restricted to whistleblowing and trade union claims in the main. Now, this case of Steer versus Stormshore, the EAT was asked to rule in relation to whether preventing people from being able to bring interim relief claims in relation to discrimination issues was in fact incompatible with the European Convention of Human Rights. What's happened is that the Employment Appeal Tribunal has essentially pushed this up to the Court of Appeal. So they have said that they don't have the power to grant a declaration of incompatibility with the European Convention of Human Rights, but the Court of Appeal do. So they've asked the court, well, not that they've asked the Court of Appeal to make a ruling on this. I should be clear on this, that actually what they've done is they've given Miss Steer the permission to appeal to the Court of Appeal. Okay. Now, if Miss Steer's appeal succeeds, then this is really going to potentially change the legal landscape in relation to discrimination claims, because what that is going to do is it's going to be a bit of a game changer in terms of the fact that anybody with a discrimination claim is then going to have the opportunity to bring a claim of interim relief, which, as I said before, in terms of the consequences of that on the employer, they are very significant indeed in terms of the cost. So watch this space. We'll have to wait and see what happens. There's no change in the law at the moment, so at the moment claimants aren't able to bring claims in relation to interim relief, albeit that actually it may be a good idea for claimants to bring claims for interim relief and have them stayed pending any decision in relation to what the Court of Appeal decide they're going to do. So an interesting one for us to keep an eye on in 2021. Agency workers regulations. Now, this case involves Royal Mail, and it's quite a, it's actually quite a, in a way it's quite a straightforward case, because essentially what this concerns is whether a company is required to consider agency workers for their employee vacancies, or whether in fact an employer can prioritise existing employees for internal vacancies and can in fact prevent agency workers from applying for them. Now, so this case then involved an argument in relation to Regulation 13 of the Agency Workers Regulations. Now, Regulation 13 provides agency workers with the right to be informed by the hirer of any relevant vacant post to give them the same opportunities as the comparable worker to find permanent employment with the hirer. Now, so the question for the Employment Tribunal and subsequently the Employment Appeal Tribunal was whether that should be read literally, i.e. that it's simply a requirement to inform agency workers of the vacancy, or whether it should be read purposefully, because there would be no point informing them of the vacancies if in fact they then can't apply for the vacancies. So what's the point of having it? So that's really where this argument went. And the Employment Appeal Tribunal concluded that it should be Regulation 13 should be read in the literal way, and it referred to the case of Coles and the Ministry of Defence. Now, the Coles and Ministry of Defence case dealt with a situation where the Ministry of Defence was making people redundant, and so those employees who were then at risk of redundancy were then put into a redeployment pool, and they were then prioritised over agency workers. In fact, they were prioritised over other employees in relation to any vacancies that the business had. And so there was a claim that was then brought by an agency worker who was saying, well, hang on a second, surely I've got the right to apply for these vacancies. You've informed me of them, I want to apply. But the EAT in that case said, no, it was entirely reasonable for the employer to prioritise permanent employees in their redeployment pool. And essentially what the court have said, the Employment Appeal have said in this case, the Angard Staffing Solutions and Royal Mail case, is that there isn't a requirement to have a justification as in the way that Coles and Ministry of Defence had, because that seems quite clear, and that was all to do with redeployment and the protection of employment in relation to those employees who were otherwise going to be made redundant. They said you don't even need that justification. The agency workers simply provide the agency workers regulations simply provide that agency workers should be informed, but there isn't then a further obligation on the employer to actually enable them to apply for such jobs and to compete for such jobs. So a bit of an empty requirement, and I've got to say that it's something that when we saw the regulations, or when the regulations were first implemented, that it appeared somewhat light, a light requirement to just simply inform agency workers that these vacancies exist, and yet on the other hand you can tell them that they've got no right to apply. But it is what it is. We are where we are with those regulations. And then finally, so this is the final case that I want to talk about, and it's a very interesting conundrum that employers often come up against, albeit that I will be getting into the sort of legalities of recurring conditions. But in Sullivan and Bury Street Capital, the issue that was at the heart of this was whether an employee who has an impairment that has a substantial adverse effect on their ability to carry out day-to-day activities, which of course is the definition which is set out in the Equality Act. But if that doesn't last for 12 months, if it isn't long-term enough to be lasting for 12 months, then one of the other tests that the tribunal looks at is whether it is likely to recur in the future. And so when we're having a look at when something is likely to recur, the courts have said in the case of SCA Packaging and Boyle that this means something that could well happen in the future. So this makes it potentially quite easy for claimants to be able to satisfy this. Now, the facts of the case in Sullivan and Bury Street Capital is that the claimant suffered from a paranoid delusion that he was being followed by a Russian gang. And this paranoid delusion that he had occurred following a breakup with his girlfriend in July 2013. This then had the knock-on effect of affecting his timekeeping and attendance at work, and also his record keeping at work. But he appeared to get better by September 2013. So of course what we're looking at there is quite a short time frame. So it wasn't something that was long term at that point. It only lasted from July 2013 to September 2013. So things appeared to revert back to normal. There were no further difficulties until April 2017, so some 4 years later. And he was then dismissed in 2017 because of his poor timekeeping. So he then brought an unfair dismissal and disability discrimination claims, and he claimed that he had a mental impairment, or should I say actually, he brought the claim that he had a mental impairment, and the Employment Tribunal agreed that he had a mental impairment from July 2013 until September 2017. But they went on to conclude that there was only a substantial adverse effect because of that mental impairment for a few months in both 2013 and a few months in 2017. So therefore, what we were then looking at is then whether it was likely to recur as a result of the substantial adverse effect that it was having in July through to September 2013. And the Employment Appeal Tribunal held that although there was this substantial adverse effect in 2013 and again in 2017, in neither case was it likely that the adverse effect would last for 12 months or that it would recur. So there was no indication from the evidence that was available that the condition in 2013 was likely to recur. And what was important in this case was what was known in 2013. And what was known in 2013 was that there was no evidence that it was likely to recur, so therefore it wasn't likely to recur, and therefore he was not disabled as per the definition of the Equality Act. But of course, what this does, I mean, this is always a very difficult area, and particularly in relation to mental health conditions, where you do have a flux of bad periods and not so bad periods. Now, in this case, of course, it's quite stark in that we've got a very short time frame within which we had a substantial adverse effect, and then a very long gap until then there was a similar effect at a later date. Often what we do tend to see is we see much shorter time frames where the condition is getting worse and then getting better and getting worse and getting better. And so within the more common instances of the mental health, as it gets better and worse and better and worse, it's going to be far more difficult to actually be able to draw such a very clear line in between two episodes as was able to be done in this case. But it certainly does open up the possibility for employers to be able to argue in a stronger way, perhaps, that a condition wasn't likely to occur, because it's been generally accepted that it's quite easy for claimants to show that something was likely to occur, and what this case does is it does focus the tribunal in on the fact that the data at that time in 2013 wasn't sufficient to show that it was likely to recur. So a rather helpful case for employers, although I do still think that actually the number of occasions on which it's going to be applicable is probably going to be rather limited, but certainly something for us to take into account. So that concludes our update for January. So I appreciate there's quite a lot of content